Hi, it's Mike DelSignore, Massachusetts criminal defense attorney. In today's video, I'm going to talk about what happens if you're charged with domestic assault and battery, but the alleged victim, your girlfriend, your wife, does not want to testify. So many people would think the case would get dismissed right away. The fact is, it doesn't. You'll still have to go to court the next day. You'll enter a not guilty plea, get another date to come back for court. There is good news. If the victim's not on board, the case may eventually get dismissed. It's just going to take longer than you wish. We have to go through the process, but eventually there's a very good chance it would get dismissed. So what you want to do is there may be an order of no abuse. Sometimes there's even a no contact. Abide by those orders. Also, very important, get help, get treatment for what caused the problem. It's going to make the victim and your relationship better. If it's alcohol, get alcohol treatment. If it's an argument you had, get counseling. Do something to improve the situation. Then the case is going to take some time. Your situation's improving. The alleged victim is happy with what's going on. Case is more likely to get dismissed. And you're also doing the right thing for yourself and for everyone involved, your family. Now, what happens if the alleged victim is not on board? Does it automatically mean the case gets dismissed? The answer is no. The government can try to prove the case based on a 911 call or an admission. So there's different ways to prove a case, or if there's an independent witness. So if someone else saw what happened between the two of you, they still may prove the case. If you confess to it, potentially they can try to prove it. And the most common way to try to prove a case without the victim on board is through a 911 call. So the victim calls 911, says, hey, my husband or my boyfriend is hitting me. Get an ambulance. I need help. I'm afraid. And then the person stays on the line. The operator will say, well, stay on the line and we'll get some information. They get some information. They ask, is the person in the house? That call could come into evidence under an exception to the confrontation clause. This goes back to the United States Supreme Court said that someone who calls 911 complaining of a domestic is not making an accusation of a crime, but is trying to get help, and that's their primary purpose. So this primary purpose test says the statement comes in. If the primary purpose is to accuse somebody of a crime, the statement may not come in. So if this is hours later, if they physically go to the police department, then the statement might not be admissible. So there'll be a hearing. Judge listens to the call. The judge would listen to argument from the lawyers about the case law and decide whether the statement comes in or is excluded. If it's excluded, that probably would be the end of the case. The case would get dismissed. So if it's your wife, she has a right to exercise what's called the marital privilege, so they can't force her to testify. If it's just a girlfriend, they could force her to testify. However, usually they don't. So typically, if the victim's not on board, the victim won't be compelled or forced to testify, and the government will try to prove the case without their cooperation. So after arraignment, the first court date is pre-trial, and hopefully you'll be able to put the case on for bench trial at that point. I prefer to put them on for bench trial on a day where there's not jurors. That way, if there's any surprises, if the victim's actually on board, we could potentially get another date for a jury trial. So steps of the case: you enter not guilty, get treatment, get help, fix the situation. If you got arrested, there's probably a problem. It could be the other person has the problem, but it's better if you do something proactive. It's never going to be a waste to get alcohol treatment, counseling, or any help from professionals that you think you need. And then at the pretrial, we'll try to put the case on for trial, move the case towards a path for dismissal. If the DA tells us there's going to be an attempt to prove the case without the victim, we'll have set it up for a motion to exclude that evidence. So that's the path to get your domestic assault and battery charge dismissed as soon as possible. But even if the victim's not on board, they can still pursue the case. If you're not a citizen, very important, you can't admit to a domestic of any sort. Continuance without a finding, even a continuance without a finding. You need, at minimum, a pretrial probation. If the victim's on board, it's going to be a strong case. You can try to work out a plea. If you have no record, you can probably get a continuance without a finding, but you have to do a program. So my name is Mike DelSignore. I help people every day fight domestic assault and batteries. If you have questions about your case, call, text anytime, 781-686-5924. I'm here to help you make the best decisions for yourself, avoid a conviction for a criminal offense of domestic assault and battery, and to answer any of your questions.